Welcome, Vicky. This is a wonderful opportunity to talk to you. This is an opportunity to talk to you about divorce. This question comes up so much with my clients who are separating from someone who they describe as narcissistic, and the challenges and complications of divorce. So we've got a few questions here for you to ask, but before we do, please introduce yourself.
Okay. Hi, I'm Vicky Medd. I'm a solicitor at Ridley and Hall. I'm a partner there as well, and I'm also a qualified mediator. I've had over 30 years. I stopped counting at 30. 30 years worth of experience. So I've come across a few situations like this in my time, both acting for a narcissist and also being on the other side of the fence as well.
And you mediate too?
Yes. Yes.
Because often, is that the first place to begin with in terms of a separation, to try for mediation?
So what the courts say is that people should try mediation before they issue an application. So the way the court system works at the moment, mediation is an entirely voluntary process. However, if you want to issue a court application, say for finances or for sorting out children, you normally have to go through a mediation appointment first, the MIAM, Mediation and Information and Assessment meeting. So you have to have met with a mediator first. That's basically because the court wants to try and keep disputes out of court if they can be sorted out better that way.
And is the mediation outcome legally binding? Because this is something that some of my clients have said, that what's the point of going to mediation? It's not legally binding.
Yeah, it's not legally binding when it leaves me. However, it's still worth going, and perhaps with narcissists, maybe not so much, but it might get you somewhere. So I don't say don't do it at all. It's one of those situations where timing has to be right, circumstances have to be right, and the narcissist might get something that they want out of it, so it might work. However, what I always say to people is mediation is a process. We're not a replacement for lawyers. So I always tell people to speak to their lawyers whilst they're going through this process. So they will be getting advice from their solicitors on whether or not the agreement's fair. Most of the agreements reached in mediation through my team do end up standing the test of time because people have spoken to their lawyers throughout the mediation, and actually it's actively encouraged, and most mediators worth their salt will do that. What sometimes happens is people do change their minds occasionally, and then we're back to the drawing board. So they either come back to mediation to have another look at it, or alternatively then litigation starts. But
another aspect that comes up, and this can be round, I mean, you've mentioned mediation and the finances, but clients have often felt that partners were hiding money.
Yeah.
What your thoughts were on that?
Okay, so in terms of mediation, I would be assessing that as not a suitable case for mediation. If I didn't feel that somebody was going to be honest about assets. In terms of, and I think it's a common trait with narcissists that they want to hide their financial picture as well. What happens at the beginning of a financial case, if we go through the court system, is that both parties have 6 weeks to file a Form E. There's lots of alphabet letters in finance cases. So you issue a court application on a Form A. I'm not quite sure what Form B is, but I know that Form E is the financial application. And there you're asked to provide all of your financial picture, 12 months bank statements, wage slips, P60s, everything. So everyone should do that within the court remit. Now, it may well be that we need to go further back. There might be some information that we need from a few years ago because there might have been a suggestion of sort of salting money away before then. And those are judicial, they're judge-led effectively. So a judge would make a decision about whether or not that was a relevant question to ask. So for example, I've had cases where husbands have had shares in businesses. Wife has said she wants to leave. Husbands have then immediately transferred shares in businesses to somebody else. That's obviously a really relevant question. And in the case I'm thinking of, the shares in the business were the most significant asset by a country mile. So in theory, everyone should provide financial disclosure. In practice, people try and get around it. And so at that stage, there's a questionnaire. so we can ask questions of the other person. And when we go through the Form E, it's amazing how much a bank statement shows. Because what we do, we don't just sit there and go, all right, he's provided 93 bank statements from last year. We do actually go through them. So quite often another account will come out because there's a transfer over there. It's only if somebody is taking out cash and quite relatively small amounts of cash over a period of time that I think it's going to be really difficult to track that back, because there's no particular paper trail. And if you ask somebody how come they took out £200 a week or a month on every Friday, what they did with the cash, people wouldn't really be able to tell you. And then you're basically asking the court to draw an inference then that this money is being disposed of. So there are different ways around it. So the court very much tell you what to disclose. You're under a duty to disclose. That's the first thing to be really aware of. And if people don't comply with that duty, courts can make costs orders as well. So they can say, right, well, you didn't provide your Form E in time, so that means you've got to pay the other person's costs of that application, and we're giving you X number of days. If they still don't provide it, you can ask the court to draw inferences that they're a person of significant wealth, that they have a lot more because they haven't disclosed it. And you can also ask it. So some people don't even participate in the court proceedings. So you can ask the court, you can say, well, look, can we send out a draft order? And obviously you're going to be after more than you would normally be entitled to in that draft order to try and bring the other person to the table. So whilst the court system, yeah, people are really worried about it, there are instances where, as I say, with cash, there's very little we can do about it. But actually, most of the time, bank statements do contain secrets, and we can look at them quite carefully.
And is this the aspect when the can starts to get kicked down the road? Is this where the delays begin to kick in?
Yeah, I mean, it's really helpful. In divorcing a narcissist, I think you need to know what you're getting into first before you do it. And in most cases where narcissists are concerned, not all by any stretch of the imagination, but in most cases, you're probably going to end up in some form of litigation. So in terms of the financial aspects, I think it's really important to let everybody know what that procedure is about, okay? So first of all, to get your application off the ground, you have to have attended an appointment with a mediator. There are certain exceptions to that, urgency being one of them. Some elements of DV and domestic abuse are another. So there are certain exemptions to it, but in the main, people have to be referred off to a mediator. So you go off to your first appointment for your mediation information and assessment meeting. The other person's offered one. If they go, fine. If they don't go, you get your piece of paper, which I always call your Willy Wonka's golden ticket to make your application to court. And it's not a great thing, but there we go. So then we file our Form A, so the alphabet all over again, with the court. And the Form A is basically your notice of intention to make your application. The court are not particularly speedy at the moment. And I think down south particularly, they're having really bad delays at the moment with getting papers issued. Up north, where I tend to practice, it's actually a lot better. We don't seem to have the same problems, but the difficulty is, depending on where you live, depends upon which court the papers are issued out of. So you're stuck with it, I'm afraid. You can't choose.
Lottery.
Absolutely, yes. So then at that stage, the papers are processed and you're given a court date 3 months after the papers are processed. And it's within this period that you file your Form E. So you give 6 weeks to file your Form E. Then there's lots of other paperwork that the solicitor sorts out for you. So you've got to do effectively a schedule of assets and liabilities that's really complicated and not the easiest form to look at. It's not my favourite form in the world. And a summary of where you are with the case as well. And then the papers go before the judge for the first time and there's a hearing. And that's called the first appointment. Quite often I call that the housekeeping appointment, because basically that's where you're saying, well, look, they haven't answered this. they haven't done that. They've really undervalued this asset, so we need a valuation. We might need an actuary to look at pensions. So it's there where we do the housekeeping, really, to get the case, you know, sort of good and tidy for when it's listed for a contest. The next stage, so at that stage, the court make all sorts of directions, which is the valuations of property, answering various questionnaires, etc., etc. And they will then list it for what's called a financial dispute resolution appointment, or FDR for short. And that's where all of you go before a judge, and the solicitors give the background, and they say what your client's case is, the other side say what their case is, and the judge gives an indication as to what they would do in a particular case. So they give an indication. They're debarred from hearing it if the case goes further, but they're basically saying, well, look, if I was hearing this case, this is the sort of order I would make. And then you give them time, they stand the case down, so everybody goes outside, and then you try and sort it out. And the majority of cases settle at FDR.
Okay.
If, however, it can't settle at FDR, the case is then listed for a final hearing. And that's where the court is given a lot more time to hear evidence from both parties and anybody else necessary. So if there's still no agreement over the valuation, you've had a single joint expert prepare a valuation of the property, there's still no agreement over it. That's where everybody else gives evidence as well. And then the judge makes a final determination. So that, from start to finish, in the north of England takes about a year if you're going all the way through. In the south of England, probably longer.
Wow.
North-south divide still exists.
Wow. Super. Well, thank you for that. So some of what you said will probably touch on some of these questions.
Yes.
Here's the first one.
Okay.
How do I negotiate with my narcissistic partner when they stonewall all attempts to get the final disclosure?
Okay, so I think that in this particular case, the chances are this person will have to make an application to court. One of the facets of a narcissist is, unless it suits them, they're not going to negotiate. And if there's nothing in it for them, they're not going to negotiate. And this is why I've said the background information is really key. It's then just about digging in and letting the court process take its course of action. The court will move this case on. They do not want cases to stagnate, so they will want to move it. Now that means lots of costs and things like that. But
which if it's a female getting divorced,
yes,
from a narcissist, she'll have to fund that.
Yeah, usually. I mean, there is legal aid available, but it's very rare. So there's certain provisions. So it has to be domestic abuse, but they're quite strict, the guidance. So somebody either has to have been convicted or have been cautioned against a DV offence, well, domestic abuse offence. Or there's all sorts of other factors as well. But again, it's worth checking that out. The other thing that there is now, and we use quite a lot, are litigation loans if people haven't got access to any other form of money. I always say it's far better if you can get a loan out, or you've got a credit card on a decent rate, or you can do the interest free and then keep transferring it over. Do that. But if those options aren't available to you, litigation loans are there to try and help. And basically, they're specialist loan providers. They charge, sadly, a premium in terms of the interest because the case they're dealing with. But what they then do is charge only the interest through the lifetime of the case. And then they take the balance out at the end of it once a payment's received. So if there was an order that there was a sale of a property, they would take the money out of the sale. So that's a possibility as well. But these things can cost thousands and thousands of pounds.
And this is obviously dependent on your credit score as well.
It is, but actually they don't tend to go with the credit score. They tend to go with what assets there are.
Okay.
So for example, if say you wanted to borrow 15,000, I think that they would need at least probably 6 times that in the pot, if you like. So the house, the equity in the house would have to be worth that, or the savings would have to be worth that, etc. But they have a look at it in that terms. And what I tend to do is ring them and say, I've got this person, these are the facts, what do you think? And then they'll give me a yay or a nay.
Okay, beautiful. Good to know, because that is another challenge people come up with,
Absolutely, absolutely. I mean,
especially the narcissist as the breadwinner.
yes, there has been provision for quite some time, but it's not been used very much. The court can order monies to be paid to assist the other person. So, for example, if you've got, I don't know, a pot of £30,000 in a savings account, it'd be great, wouldn't it? But Narcissist has that in his account rather than the other way around. If you can show the court certain things, and one of the things you have to satisfy the court is that you've been refused for 2 loans elsewhere. But if you can satisfy the court on certain things, the court can make an order that they pay a figure for your legal fees. It's not being used massively because of the hoops that people have to jump through, and of course the cost of actually going to court to get an order to get the fees, which is why litigation loans have come in more. But nevertheless, that's an option that's there as well.
Okay, brilliant. Thank you. Here we go. There's another one. I'm currently in the middle of divorce proceedings with my ex, who has refused to negotiate or discuss the process at all, and who's used delay tactics throughout, resulting in me incurring substantial legal fees while he represents himself. We're having to live with him in the family home, including my teenage daughter, until resolved. I have a very supportive solicitor, but do judges take any of their behaviour into account when dealing with financial settlements? Do they have knowledge of dealing with narcissists as a rule?
Okay, so first of all, I'm so sorry to hear that. That must just be the most difficult situation when you're living in the house with the person that you're divorcing and they're a narcissist. It's not going to be easy. So my heart goes out to you. It really does. And I hope you're keeping yourself safe and sane as much as you possibly can. What I would say is that the courts are not necessarily drawn attention to narcissistic behaviour as such, but they are drawn attention to behaviour. And the court has to make allowances for behaviour if it's considered inequitable of the court to disregard, which basically means it's so bad that the court can't ignore it. The bar is incredibly high for proving behaviour, and in my over 30 years, I've only probably had 3 or 4 cases, and some of them have been absolutely horrendous circumstances, which I won't go into today. However, the court can also make orders for costs if somebody's litigation conduct is really bad. So, for example, if this person delayed with filing their Form E, and you get to the first court appointment and you've had the Form E a week because you left it to the last minute, your solicitor can ask for an order for costs against that person. So the costs of having to attend the court, the costs of time wasted. Orders for costs never used to be a thing in family law. They're becoming a thing a lot more now. And whereas the starting point was always you both pay your own legal fees, now there does seem to be a lot more of a judicial emphasis on people abiding by court orders. So it's certainly something that can be done. Now, I have to say, different judges, depending on whether they've eaten raw steak or muesli for their breakfast, make different decisions. So some judges are really brilliant at making the costs orders, others are not. Equally, I think some judges are really brilliant at assessing people's character and others are not. So you get some good judges and you get some bad judges. So on top of the postcode lottery, you've also got the judge lottery as well, I'm afraid.
And as I understand, women in these situations have been encouraged to stay in the house, as I understand as well.
Yeah, I mean, it's one of those situations. I always say to people, do what's mentally right for you, because obviously this is, and again, it's a marathon, is going through divorce proceedings, and you need to feel safe. And sometimes for somebody to go through that marathon, they need to be out of the house, and we fully understand that. If, however, you can stay in the property, it's far better if you do so. And the reason for that is you've got a degree of control over the situation. Once you're out of the house, if you're wanting an order for sale, Mr. Narcissist can say, oh, well, you know, there's rats in the cellar and all those sorts of things, and can put you off. The other thing is, in terms of negotiating power, you haven't got any once you're out of the house because they're in. So again, it's about negotiating power and strength, and that quite often impacts on how well and how quickly we can get a result.
Wow. Another question. When a narcissist is lying about his finance, how does one go about this? I think we've touched on it, but
Yeah, I think we have. I mean, again, as I say, it's a difficult one. If somebody's working, for example, if somebody's self-employed as a narcissist, it's very difficult to prove how much money they're going to be getting. That might seem massively important to you, but speak to your solicitors, because it's not always the case. So don't go chasing rainbows that you don't need to chase. It's a bit like, I remember when my children were younger and somebody said, pick your battles, Vicky, with them. It's the same. Pick the battles that are important. This might be a case that isn't really about income, it's more about the capital. In which case, whether they're claiming 50,000 a year or 30,000 a year probably isn't going to make that much difference. It might be an argument that they use, but don't get sidetracked. So again, pick your battles, number one. If you've got a solicitor that you trust, they will be able to give you advice about this. Quite often you feel that the narcissist is running roughshod over everything. Sometimes just let them, because actually the important points are the ones that we need to save our energy for and our costs for. And quite often less is sometimes more. Don't bring an argument to a narcissist unless you absolutely need to.
Absolutely.
But as I say, other than that, I've touched on it. In litigation, the courts require you to file a Form E. If he's not been telling the truth in the Form E, it should be fairly obvious from the documents that he has provided, he or she has provided. And equally, if they haven't provided any documents, there is a process you can go through. So you can go through the court ordering it, the court ordering him to pay costs because he hasn't provided it. And also, if they still don't and they're still going down that route, you ask the court to draw inferences about their financial circumstances.
Okay.
Okay.
Fourth question. How can I best prepare myself mentally, emotionally, or financially for a narcissistic husband who I know will make a divorce even more painful and is likely to aggressively or passively withhold information or communication?
Well, I think part of that one's for you, actually.
Absolutely. Yes.
Go ahead.
Yeah. But in terms of, even in terms of the marathon, which can be enduring,
Yes.
financially, how would you encourage people to prepare for a marathon?
If you can save money in advance, do so. I think that's the first thing. Have a good group of people around you. That's the second thing, because solicitors are expensive. We charge for things, sadly. You do not want to use me as an emotional crutch.
Absolutely.
You need to speak to somebody like Keely, somebody who can help you heal whilst you're going through this process and help you understand. And that's really important. And also support of friends and family. And it may well be that you've been distanced from friends and family by the narcissist. Try and get back in touch with them as soon as you can. Find out as much as you can about the process. That's why I touched on it at the beginning. I think it's massively important that you get as much information as you can. Look into the loan position if you're looking at finances. Speak to a solicitor in advance of you leaving. Most solicitors do either a free half-an-hour interview or alternatively an initial fixed fee paid appointment. And I quite often see clients, 12, 18 months, sometimes 2 years before they actually finally leave to talk things through. And during that time, they've kind of developed a strategy. So, and I think the most important thing is try and keep yourself as emotionally well as you can, because as I say, it's a marathon, not a sprint.
Beautiful, thank you. Last question. If a divorce goes through without declaration of assets, what happens?
That's quite a difficult one to look at, really. Normally, the divorce is kind of running alongside the finances, so I'm assuming we're talking about the financial settlement. So if the two of you reach an agreement, normally the court want you to enter it, well, you're advised to enter into a consent order, a financial consent order, so that agreement becomes legally binding. As part of that, you have to fill in what's called a statement of information. It's a 23-page form. It's a nightmare. It used to be 7 pages, but they've added another 16. I think that's right. And basically ask for all of your financial circumstances. However, it just asks for you to put, for example, properties. So what equity you've got in the property, what savings you've got, what pensions you have. It doesn't ask for financial documentation to support it. So it depends where you are on the scale. If you want the agreement to go ahead, you know that they haven't disclosed, but you think, sod it, I'll just take my chances anyway. That's what I want to do. You're both asked to sign this form. You're signing to say that what you've said is true. He's signing to say what he's said is true. Okay. And that you've both seen each other's financial documents. That doesn't mean to say that you're saying their documents are true. Okay. So you can allow it to go through. Equally, I've had cases, and I've got one on at the moment where husband has he's gone like that with a figure for his business, and we've gone back and asked the question, how have you arrived at this valuation? So you still can ask questions and see if you can get an agreement. If you're still not happy with it, then at that stage it's whether or not you're prepared to walk away from the agreement. Okay. But then the statement of information goes before a judge. A judge will have a look at it, and the judge isn't there to just rubber stamp it. The judge is there to see whether or not it's fair. Now, not all of them, not many of them are refused, but some of them are actually, if they don't think it's a fair agreement.
Right. Okay. It's disproportionate.
Yeah. Yeah. So I have had ones where they've said, no, we don't think this is fair. Why are we moving away from equality? Doesn't seem to be a good reason to do so. So they will do that. And sometimes that enables people to have a bit stronger position, but you can't rely on it because you don't know which judge is going to get it on that day.
Absolutely. Vicky, thank you so much.
No
That's
problem.
a wealth of information for me to.
Okay, no problem.
I would definitely be signposting onto you.
Thank you.
How do the viewers find you?
Sorry?
How will they find you?
Okay, so probably our website, which is www.ridleyandhall.co.uk. So if you just Google Vicky, V-I-C-K-Y, Medd, M-E-D-D, I do come up with a dreadful picture. I think my hair's changed since then. Menopause has had its fun. But yes, absolutely. But yeah, that's probably the easiest way to find me.
Brilliant. Thank you so much for answering.
Thank you. Thanks so much, Kaylee.
Bye. Take care. Bye now.
Bye.